Matter of K.Y.Z.
The Center for Family Representation by Emily Wall for the appellant father. I'd like to request 2 minutes in rebuttal.
Yes.
The family court found that the agency's efforts to reunify my client with his son had been minimal, that it could have done more, it should have done more, and it had even failed to follow the court's orders. These findings are inconsistent with the family court's determination that the agency proved by clear and convincing evidence that it had made diligent efforts to reunify the family.
So, since you disagree that this is the minimum, which is what the court decided, what would be the minimum? What's the floor? What else needed to be done?
Well, Your Honor, the agency was required to determine the particular problems facing the parents with respect to return of the child and make affirmative, repeated, and meaningful efforts to assist the parents with overcoming those efforts, as this court said in Sheila G. And so the primary obstacles that were facing my client with respect to return of the child were his understanding of his wife's mental illness and his frequent work out of state.
As to the first one, I'm a little confused about what the agency could have done, because I think the allegation was that he was not accepting his wife's illness, mental illness. So I don't really know what it is that they could have done differently. It's not like he's saying I didn't understand it or I need more education on it. He was basically saying, as far as I could tell from the record, I don't accept this. So what do you think the agency could have done?
Your Honor, I'm not sure that it was an issue of refusing to believe it or not understanding what it consisted of. I think the agency was obligated to explore what it was that was preventing him from having the kind of understanding the agency wanted him to have about her mental illness and help him overcome that obstacle.
With respect to understanding, how was it conveyed to him? Was language a barrier? Was education a barrier?
Your Honor, I believe the only time the agency spoke to my client about his wife's mental illness was at the planning meetings, which were held every 6 months, twice a year.
Did they have an interpreter there?
They did have an interpreter at those meetings. Initially, I believe it was a Mandarin interpreter, and at some point it began being a Fuzhou interpreter. But the case planning staff who attended those meetings didn't have any, there was no evidence that they had any expertise in mental illness or whether that they had the cultural competence necessary to help my client overcome any cultural barriers to his understanding of his wife's mental illness.
What, if any, services were provided to address that particular issue? Anything?
No services were provided to address my client's understanding of his wife's mental
So
illness.
what happens at the planning meeting? They just say you don't understand?
At the planning meeting, they would say that that the wife was not able to care for the child due to her mental illness, and I believe that was about the
Did
extent.
they offer therapy for him?
They did not.
Didn't they ask him to go to the wife's therapy sessions, presumably to get a better understanding of the nature of her problem?
So the case planner testified that my client had been informed that he could attend the wife's therapy with her, but that wasn't a meaningful opportunity for him to gain an understanding of his wife's mental illness because she didn't regularly attend her therapy.
I know, but why not? I mean, I think you're suggesting that the father should have been offered some kind of mental health therapy, but he didn't need it. So they're saying, look, you're not accepting your wife's issues. Maybe you should attend these issues because that'll help, these sessions, because that'll help you understand. Why isn't that sufficient? Again, I come back to, I don't know what the agency could have done to force him to accept this notion that his wife was suffering from mental illness.
I think the suggestion that he needed to be forced to accept it, I think, presumes that he understands it and is refusing to accept it, which I don't think is clear.
And what are
as
you
the case.
saying impacted his ability to understand and appreciate the effect of her illness on her ability to care for the child?
Right. I think that there may have been cultural barriers to his understanding of his wife's mental illness, and I do think that individual counseling is a service that can assist someone, even someone not diagnosed with a mental illness, to better understand mental illness. There's also support groups.
Would you
for-
suggest that's akin to like parenting?
Yes.
But dealing with him as an individual. So what is the agency's responsibility with respect to providing services for an individual?
Well, they need to tailor the services to the individual situation. And as I mentioned before, they need to determine the particular problems, whatever the obstacles are, with respect to that parent's ability to reunify with the child and help the parent overcome those obstacles.
Counsel, I have a more basic question. There were findings made, there's a decision at the lower court, then that's affirmed at the appellate division. What's our standard of reviewing this?
Your Honor, I believe that the issue of whether the appropriate standard was applied is a question of law that this court can decide. And
But if it was the appropriate standard of reviewing these, what's our standard? Because I look at this record and I see over the course of almost 2 years, in 2019 to 2020, there are 10 hearing dates for fact-finding hearing. Then the next year, from September 2021 to September 22, there are 6 hearing dates for dispositional hearing. So after those 16 hearing dates, presumably where all of these things that we're talking about were discussed, there were decisions made. What's our role here in reviewing what's now, I think, 9 years of litigation over this, well, 8 years of litigation and hearings? And now, is it our role to say what type of therapy might have been provided to your client?
I think this court's role is to determine whether the family court applied the appropriate standard, which is the standard this court set in Sheila G., and that the agency make affirmative, repeated, and meaningful efforts to help the parent overcome the problems.
And is that in our view, like we just de novo review whether we think we would have done that?
Well, Your Honor, the family court did not find that the agency had made any efforts that were addressed at overcoming the primary obstacles to reunification. So the family court misapplied the standard when it approved the efforts despite...
What are you asking us to do if we agree with that? Send it back so they just apply the right standard? Are they going to have more proceedings? Are they going to give it another year? What happens?
Your Honor, I think that the order terminating my client's parental rights should be reversed, and the agency can always file another petition.
And we start over again.
Your Honor, in addition to the agency failed to take steps to address the underlying obstacles to reunification and also failed to tailor its assistance to the family's language needs.
On the language point, what are we to make of the statement that your client had, I think the word was average, language skills in Mandarin?
Well, Your Honor, I don't think the court needs to specifically address whether Mandarin or Fuzhou was the appropriate language, because in this case, to provide my client with services in, because in this case, the agency didn't provide my client with services in either language that were tailored
So
to...
you're not relying then on the provision of whatever interactions there were in Mandarin as opposed to Fuzhou?
Right. I don't think the court needs to decide that because no services were provided in either language to address the fundamental issues.
So you're saying the record is completely devoid of any services that were provided even in Mandarin?
No, I'm saying no services that were tailored to addressing the underlying problems preventing reunification. The
So
services...
it's really not a language issue at all, it's just the appropriateness of the services that were provided?
Yes, with regard to services, I would be focusing more on the appropriateness of the services.
How can that be? If you're not able to communicate with the parent to appreciate what are the services that they need, because there's a language barrier,
Yes,
isn't
well-
that then, getting back to Judge Halligan's question about whether or not, in part, the argument here is regarding the lack of appropriate linguistic services?
I agree that especially in a case where insight is so important, as in this case, that the speaking to the parent in the appropriate language is going to make a big difference. And is
But
important.
how can we conclude that Mandarin was not appropriate when there was testimony that he had average skills in Mandarin? That's what I'm wrestling with.
Right, and I don't think the court necessarily needs to decide that, because in addition to no
So
specific...
does that mean I just want to make sure I have your argument. With respect to any interactions in which there was only a Mandarin interpreter provided and nothing in Fuzhou, I understand you're making a distinct point about additional services you think should have been provided, but that we don't need to be concerned about the question of whether Mandarin was an appropriate language in which to provide an interpreter.
I don't think the court needs to decide that in this case. There were so many interactions that took place without any interpreter at all. For example, when my client came to the visits and no interpreter was provided, which prevented him from having regular conversations in any language with the case planning staff about.
And in addition, in the record at A627, was there some discussion of illiteracy on his part?
That's correct, Judge. My client testified that he is illiterate in his own language. So that obviously was an obstacle for him to understand, to be able to access services on his own.
So what could just average understanding of Mandarin mean?
And I don't know, Your Honor. It's not really in the record. The case planner testified that he gave logical responses when she spoke to him in Mandarin, but then, I don't think that the case planning staff was really qualified to assess his language skills.
And the court below, there were some comments made by the court when it rendered its decision with respect to some deficiencies.
Yes. The court indicated, if Your Honor is referring to the language about the agency's efforts being minimal, that it could have done more, should have done more, and had failed to even follow the court's orders, which I think is a clear indication that the court had some hesitation about whether to approve these efforts, which is inconsistent with the clear and convincing evidence standard that the court was required to decide this case under.
I get that a judge might conclude that even the failure to comply with certain orders doesn't mean they have not otherwise satisfied their burden. But it is troubling for a judge to say they should have done more. I mean, unless the judge is saying as a moral, something moral requires that you do more than this. But otherwise, that sounds like a judge is saying, despite the contrary conclusion, I don't find that you've complied with your statutory obligations.
Yes, and also I think that the statement that the agency could have done more suggests that it wasn't an issue of, that it was too difficult for the agency to provide my client with additional services. The court actually noted in the written decision that the court was not persuaded by the agency's excuse as to why it took 2 years to make the first referral for my client.
Why is the notion, the statement that the agency could have done more, should have done more, but the efforts were, I think the phrase was minimally adequate or something along those lines. Why is that not legally sufficient in terms of the standard that we have?
Because the court apparently thought it was sufficient for the agency to schedule planning meetings, schedule visits, and refer my client to a parenting class. But that's not what this court has held. This court has held that the efforts have to be tailored to the specific problems facing the family, not just the usual plan, and that they have to be affirmative, repeated, and meaningful. So they can't wait for a parent to ask for a particular service. They have to affirmatively sit down with the parent, figure out
And that
what is
missing
needed.
service is therapy for the father.
Well, something, yes, individual counseling or a support group or a class to learn about mental illness, and also some kind of assistance to help him overcome the obstacle that his work schedule posed to him visiting frequently enough.
Let me ask this, let's circle back to this issue of indicating that he could attend his spouse's therapy. And you said, well, she didn't really attend therapy, so that's not much of an offer. But let's go with attending the therapy. I mean, did they arrange for someone to then discuss what went on in that therapy session to help him better understand? What was going to be the follow-up to the mere attendance?
There was no, the agency
It's not
presented
his
no
therapy.
evidence. Right.
Right? It's her therapy.
Right. And the agency presented no evidence that they even coordinated, a time when he could attend with his wife. The agency case planner simply testified that she had spoken to the mother's therapist and she had learned that our client had been informed that he could attend the mother's therapy. So it wasn't like an active, affirmative effort they made to coordinate, a time when they could both sit down with her therapist and talk about how her mental illness impacted her ability to be a caregiver for the child.
Thank you.
May it please the Court. The Legal Aid Society by Andrew Ford on behalf of the child. I would respectfully submit to the Court that the Appellate Division First Department properly concluded that a sound and substantial basis in the record supported the family court's finding that clear and convincing evidence established that the appellant permanently neglected his now 11-year-old child who had been in foster care since shortly after his birth, notwithstanding the agency's diligent efforts, i.e.,
What
reasonable.
efforts can you identify that they engaged in to address the specific needs of the father?
With regards to appellant's need to understand his wife's mental illness and its impact on her ability to safely care for their child unsupervised, the agency counsels him repeatedly as to the need for supervision and that she could not be alone with him given her mental health issues.
And when you say they counseled him, is there also evidence that it was explained to him the nature and extent of her illness?
The case planner testified that at the conferences, they discussed with an interpreter her mental illness and then impact on her ability to parent such that he had to ensure that she would not be alone with the child if reunification occurred. Furthermore, once it became clear that appellant was still unable or unwilling to acknowledge his wife's mental illness and the impact.
What if he didn't understand?
There's nothing in the record to indicate that appellant did not understand what was said in terms of language or education.
Well, there's evidence that he was illiterate.
Yes, Your Honor, but illiteracy does not necessarily mean an inability to comprehend a spoken conversation. And
Nor
at no
does it mean
point-
that one can understand.
That's correct, Your
And
Honor.
whose burden is it to establish that he did in fact understand and appreciate the nature of her illness?
It is the agency's burden to establish that it exercised diligent efforts.
And in order to understand the nature and extent of that communication, it needs to be clear that he is, there is an interpretation that he's participating. How was that done? There are two languages done at different times. How was that done here?
Yes, Your Honor. With regard to the interpretation, during the first year, the agency used Mandarin interpreters to speak with appellant. During that time, appellant confirmed through the interpreter that he understood the agency through the Mandarin-speaking interpreter and provided logical, clear responses to the agency's inquiries of him.
With
I'm sorry,
respect to the visits.
where in the record does it say that he says, "I understood everything that was said to me" to the Mandarin interpreter? Just so I know where to look. 5 minutes.
One moment, please. One moment, please, Your Honor. I need to find the correct page.
Well, I don't want to take up all your time with
But
that
it-
search. I'll eventually find
specifically,
it.
I did reference it in my brief, the specific
we'll
page
find it.
numbers.
Thank you.
And I will note that during those conversations, there's no evidence that appellants ever expressed confusion or lack of understanding of what was being said, nor is there any evidence that the interpreter ever raised a concern. And
Go ahead.
with regards to his own testimony, appellant testified that the agency spoke with him about the need to ensure that his wife is not alone with his child many, many times, and that he did not testify that he did not understand those conversations. In fact, he
Didn't he say
testified.
didn't he say he'd get a babysitter?
Excuse me, Your
Didn't he
Honor?
say he'd get a babysitter?
He testified at one point eventually that he would get a babysitter for half a day when he worked more than half a day. It was clearly indicating he did not really understand the need.
Well, it's indicating that the person lives on subsistence wages, and it's very difficult for him
That's
to make ends meet. Did the agency in any way address what is so obvious, the poverty and economic obstacles to this man being able to have his child with him?
I will respond to that, but first, if I can just finish my last thought.
Yep.
The agency didn't, the appellant testified that he did not think it a big deal that his wife be alone with his child. He did not, despite being aware of his diagnosis, aware of the agency's position, and despite sitting in court and hearing mental health professional's testimony, he still did not see the issue with this child being alone with his wife. So I'd submit his lack of understanding was clear. With regards
As
to...
the Mandarin interpreter said that that's what he said?
That was the Fuchao interpreter was in court for his testimony in court, Your Honor.
Thank you.
And with regards to poverty, I would submit to the court that the appellant's schedule or need to work or his self-imposed need to work outside the state was not the primary barrier to reunification here.
Self-imposed?
Yes.
Was there evidence that there was work readily available for him and he simply chose to avail not to seek those opportunities?
Yes, Your Honor. Appellant testified that he worked with several employment agencies in New York City that found him work. He testified he never asked them to find him local employment. He testified that during the last 6 months of the relevant period, he was able to work sometimes in New York City. And he testified that in the 2 years prior to his testimony, he worked for 2 years straight in New York City, establishing he could, in fact, work in New York City. He did not testify he could not work in New York City at all during the relevant period.
But I thought he communicated that being able to go out of state, and these were not convenient trips, these were exhausting trips on these buses, because he works in the restaurant industry, was one way to increase the amount, again, of these very subsistence wages that he made, so that he'd have more money. I mean, he didn't have disposable income.
Yes, he did testify that he thought he could make more money by working out of the city and out of the state, which is why he chose to take those opportunities.
Is it possible that he would consider that beneficial to reunification with his child, if he could move above this clear poverty status that he was at?
I would submit to the court that parenting, by its nature, requires parents to make tough decisions, and parents make the decisions that they think are best at the time. I can agree to that. In this particular case, he decided
Can you also agree
to-
that the agency might have some responsibility to assist with
Certainly.
the crushing load of some of those decisions in this kind of parent's case?
Certainly, Your Honor. If the barrier to reunification was his mere lack of availability to visit more, not his understanding of his wife's mental illness and its impact on her ability to parent safely.
If I understand the record correctly, the visits between the father and the child that were arranged by the agency, the child had been placed in a home where neither Mandarin nor Fuchao was spoken, is that right?
That's correct.
And there was no interpreter provided at those meetings?
When you say meetings, which area are you referring to, Your Honor?
The visits with the child.
So, yes, when the child first entered
So
care.
basically, they took a child who would have been a native either Fuchao or Mandarin speaker away from the parents at birth, put the child in a home where neither of those languages was spoken, and then arranged for visits between the child and the parents where there was no interpreter. And just to finish the point, they also didn't, during the 11 years of this child's life, ever provide instruction to the child in either Mandarin or Fuchao.
One correction for the record,
Yes.
Your Honor. I believe the dispositional hearing established that the agency did arrange for some Mandarin instruction once he was older and able to start.
so how
Mandarin
many
instruction.
years-
But my apologies.
Go ahead.
But with regards to during the fact-finding period, yes, my client was placed in an English and Spanish-speaking foster home. The agency scheduled twice per week visitation with the appellant and his child.
A series of 3 different foster homes, no?
During the relevant period, it was
Yes.
only one foster home throughout that entire time. And the agency explored a
And the
potential-
relevant period ends at age what?
He had just turned 3 years old, I believe a month or two prior to the filing of the petition.
Was he verbal during that period?
No, he was completely nonverbal according to the testimony for the first 2 years, and the third year he was, quote, limited in any language.
But during the visits for all 3 of those years, and it sounds like you're saying going forward, even if the relevant period is not before us, there was no interpreter provided during the visits. And so the father could not communicate verbally at all with his child. Is that right?
During the first 3 years, there were no interpreters at the visits, but I would submit to the court respectfully, if there was no need for an interpreter, appellant himself testified he did not need an interpreter to speak with his son when he was a baby.
I think that many parents do speak to their children even before their children are verbal. And so it might have been, maybe you could agree, beneficial for the father to have had an interpreter that would have enabled him to do that.
I would submit to the
Also,
court
I'm
that-
sorry, weren't those visits supervised by the caseworker?
Yes, Your Honor.
So it
visits-
meant that without the interpreter, there could be no communication with the caseworker?
Yes, Your Honor. Visits were supervised by a case planner throughout the relevant period. With regards to appellant speaking to
What
the
was the
child, there
purpose
was,
of the caseworker being there?
visits were supervised by the agency. I believe it's not,
And do they provide input to the parent if things are not going, or they're doing things that are inappropriate?
their supervision is meant to be there to ensure the visits happen safely and to intervene and/or provide guidance if there are issues. or
And how
safety
can you provide
concerns.
guidance if you're not speaking the same language?
I would submit to the court that there were no safety concerns identified with regards to appellant's ability to communicate or interact with this child during those visits according to the agency's case planner. There was nothing in the record to indicate the agency ever stopped, prevented, or discouraged appellant from speaking to a son in
What
Mandarin or
about
Foochow.
guidance? You spoke of guidance. In order to receive guidance, one would need to be able to properly communicate with another, correct?
That's correct, Your Honor, but it does not necessarily have to happen in the moment during the visits. The record established that in addition to the bi-yearly conferences, there was also phone calls between the visits with an interpreter, during which at any point in time, the agency can raise issues, and appellant can ask questions if he has any regarding the visits. In fact, appellant himself initiated several of those phone calls according to the testimony. So I would submit that there was ample opportunity, if there were concerns or questions regarding their interaction or.
Let me ask you this. Did the father at any time refuse to follow through on a service that was recommended, follow through on a referral? Did he at any time refuse to do what the agency, in that sense, with respect to the services, offered to him and encouraged?
I would submit there were two things.
Okay.
First, with regard to the visitation, he was offered twice per week and was only reduced to twice per month at his request, and even then, he only visited about half the time,
And I
once,
thought that was,
sometimes twice.
but I thought that was because of the parents' work schedule.
That was because, I was at his request because he was working out of state. However, he did testify he would come back to New York City more often if he had things to do and did not if he did not have things to do. The agency provided financial assistance for the actual transportation. Clearly,
On the buses out of state?
for the Metro cards, and he testified they offered to provide him reimbursement for the bus tickets, but he'd never provide them a receipt. So he had ample opportunity, if he chose to prioritize visiting more often, to come back to New York City with financial assistance to visit his son more.
But the financial assistance might mitigate the costs of the travel, but it would not make up for the lost, right, the lost wages.
Potentially, Your Honor. It's not clear from the record how much time off he would have to take from work or how much that would cost him or
Let me
how
ask
that
you
would
this,
affect him.
is this record aberrational?
In what way, Your Honor?
Well, the caseworker couldn't figure out for almost a year that the gentleman's primary language was something other than what she had assumed.
I would submit that that is not necessarily an issue with the agency. I would say it's an issue with the fact that appellant did not ever express to the agency he spoke another language, preferred another language, or his first language was not Mandarin. He gave no indications he could not understand Mandarin or he spoke another language. The agency,
Well, how did they
Did not
make a
know.
determination that Mandarin was appropriate?
it's unclear from the record what led to the initial conversation happening in Mandarin, but during that conversation, he confirmed he understood, never identified another language.
You know, there's understanding and there's understanding, you know? And when you're going to have referrals that might involve both emotional and perhaps highly technical or legal matters, you can't just have the kind of conversation you might have at a restaurant when you're reading a menu. You've got to be able to know detail and be specific.
Certainly.
So it's a little bit, I'm a little bit shocked at an agency thinking that, you know, for 1 year or more, we got it wrong, but that's okay because there was some back and forth some way or another.
Certainly, I agree there's a difference in understanding different types of conversations. However, appellant himself testified he spoke average Mandarin for a Mandarin speaker. He did not testify
Okay, but
to any.
again, how could the caseworker and the agency understand what he meant by average, since the man has already admitted he's illiterate in his own language, his primary language, speaks a handful of words in English. I mean, it's obvious he can't communicate with the foster parents.
I would submit that the record establishes he speaks Mandarin. He does not testify to any deficiency in understanding or speaking Mandarin. He did not testify that he did not understand any of the conversations with the case planner. So while I understand the concern that the agency did not specifically inquire or otherwise confirm, according to the record, it's clear that he actually understood, and appellant was not prejudiced by the use of that interpreter, as when they switched to a Fuzhou-speaking interpreter for the following 2 years, there was no change in anything in terms of his understanding or his actions. And I would note that even if this
The
court...
interpreter was present how often? Were they present at every planning session?
There were interpreters at the conferences and at the phone
Which were how
calls
frequent?
About twice a year. There is testimony that there was no interpreter for 2 conferences, but they were rescheduled. Appellant himself confirmed in his testimony that he attended at least 6 during the 3 years. So there were interpreters at the conferences, during phone calls, home visits. It was just the visits when the focus is on interacting with his young child, and he was nonverbal, and appellant could speak with his client, with his child in Mandarin or Fuzhou, that there were no visits. And I would submit to the court that even if this court were to find that the use of the Mandarin interpreter during the first year was an issue based on the record, that does not prevent or preclude a finding of diligent efforts in that there remain 2 out of 3 years they used a proper interpreter, and only a 1-year period is required for a finding of permanent neglect.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Jeffrey P. Berman, and I represent the respondent, Good Shepherd Services. I'm not going to reiterate the arguments of the attorney for the child. I would like to address, first off, though, what the family court judge said about minimal efforts.
Can I just ask you to clarify something?
Sure.
You note in your brief, I think, that ACS policy generally requires that an interpreter be present for visits, and I don't think it's in the record, but the ACS language access policy on their website accords with that. In fact, it says that interpretation services must be provided for all in-person services. So why was there no interpreter provided for all of the interactions between the father and the child?
So, Judge, initially there was no interpretation at the visits. It's unclear why.
Well, during the
but
3 years in the record, maybe I missed it, but I didn't see any indication that there was an interpreter at the visits that the father had with his child. But did I miss?
No. Prior to the filing date of the termination, yes, there were no interpreters present during his visits. The question was, though, is an interpreter necessary? I know Your Honor had mentioned that a parent might like to speak to their child.
And I thought in particular the 3rd year, I thought the record indicated that even if he had some developmental delays, that he had some limited verbal skills in that 3rd year.
Very limited. But
no ability to communicate verbally, though, because of the absence of an interpreter. So why was that?
well, with an interpreter, the child really wouldn't have understood. But they wouldn't have really been able to communicate. The father would have spoken. The child wouldn't have understood.
The policy doesn't appear to me to say you have to have an interpreter for family visits once the child is verbal. It simply says, and you seem to concur, that policy generally does require that an interpreter be present. So I'm just trying to understand why the policy apparently wasn't followed here.
Well, that is the best practice, and it's unclear why the policy wasn't followed. It's not a requirement for diligent efforts, I would submit, but it would have been helpful. However, the main purpose of the visits really is to bond, right? So you want the parents to bond, you want the father to be able to hold the child.
And
see his face.
presumably, as I think the attorney for the child stated, to receive some guidance, which would be not possible. An interaction with a child, one would think that guidance in the moment is particularly helpful. And I take it that was not possible absent an interpreter.
Right. However, the record is pretty clear that there was guidance given after the visits via phone calls, via planning conferences, with the benefit
Which
of an
took
interpreter.
place twice a year,
Well, the
perhaps.
conferences did. The phone calls were more frequent. But the planning
How
conferences...
long were the calls?
It was unclear how long the calls were, but an interpreter was utilized for
What
all
were
of the
the
phone calls.
subject areas covered during the calls?
I believe the caseworker spoke about the visits and spoke about planning. I'm not sure what else
But
was
if you're
discussed.
trying to get a parent and child to bond, sorry, straight ahead of you, why would you put them in a place where they can't speak the language that is the only language spoken by the parent? I mean, that seems counterproductive to bonding, no?
Are you speaking about the foster home or the visits?
The foster home or the visits? Well, look, what I'm speaking about, I guess, is you have a child who would have been a native Fuchsia speaker, maybe would have at some point learned Mandarin, probably not, right? And parents who speak only Fuchsia and Mandarin, and a child who's put in a home where the only exposure to language is not in either of those languages. So if you're trying to get a parent and child to bond, that seems like the opposite of what you do. If you were trying to get them not to be able to bond, you would give them different languages and different cultures.
So is Your Honor suggesting that they should have tried to put the child in a Fuchsia or Mandarin speaking foster
There are
home?
many things that might have been done. That certainly could have been one of them. And even if the initial placement couldn't have been there, there might have been a continuous look for a place that could have provided that. Or, for example, a daycare where Mandarin was spoken, or language instruction in Mandarin. Even, I mean, the way, as Judge Halligan was getting at this point, the way children learn language is not by being presented books, it's by their parents, generally, or some adults, or maybe other children, speaking to them in a language. That's how they learn. That starts when they're born.
Yeah, I mean, certainly immersion would be the better way to do it. But in
It's the
terms of the
only
foster
way
home,
people learn language, learn their initial language, is immersion. Nobody learns their initial language when a 1-year-old by picking up a textbook.
right, but that would likely require the agency to have a Fuchsia or Mandarin speaking foster home available at the exact time that the child was.
Did they look to see if there's a Mandarin daycare?
I don't know if they looked to
Records
see if
say
there
that?
was a. They did explore the father's resource, who would have been a Fuchsia speaking resource. He presented a resource. The agency explored them, tried to certify them as a foster parent. However, they dropped out for one reason or another. It wasn't clear why, but that would have been a perfect home for the child. If that resource had followed through, that would have been an immersive environment for the child. It would have been a Fuchsia home,
Or
not
perhaps
just a
figure
Mandarin.
out before 1 year what the primary language is of the parents, perhaps provide the parents greater resources to ensure reunification. That was the plan.
Well, Your Honor, in terms of that first year, I think the responsibility is equally on the father. If he didn't
But that's
understand
not,
what was
you
being
have a
said.
burden. I'm not disagreeing with you. Obviously, the parent can't undermine the agency's efforts or throw their hands up and say, I'm not going to do anything. You've got to serve it to me on a silver platter. But I had asked before, and let's see if you have a different opinion. I thought the record indicated that the father did everything he was asked to do, got certificates and programs every time he was asked to
Well, he
take
went-
those programs.
He went to a parenting program. He did that, and he did it in Mandarin, which the agency found for him. He didn't attend the mother's therapy appointments, which
But
would have
neither
been...
did she many times.
Well, if
And it's
this-
not his therapy, it's hers.
It's her therapy, but if this man's plan is to plan together with his wife, and she's not attending his therapy, well, that's not a very good plan on
Well, I
his
thought
part.
the agency thought the child can't be in the care of the mother.
Well, they did, but he didn't. His
So
plan was...
what about that, though? If, as I understood the record, the mother was attending therapy appointments quite sporadically, yes?
Yes.
Okay, and presumably, the father, I guess, could attempt to persuade her, but he can't compel her to attend the therapy appointments. So what should or could he have done, and at what point does the agency have an obligation to identify other routes towards him improving his understanding of her condition and whatever risks it might pose?
I think that was really the best route. And again,
Well,
he
but
wished
wait,
to plan to...
but if she wasn't attending regularly, that doesn't provide him with much of an avenue, it seems to me, because he can't make her go. So how is that a meaningful avenue?
So my point is that if they are planning together, right, they want to raise this child together, that's their plan. He has to take some initiative to try to persuade her to go. He can't force her to go, obviously.
We don't know whether he did or didn't take some initiative to try to persuade her. I think what we know is that she only went sporadically, right?
Right, and the agency encouraged her to go more.
Yes.
But he didn't
But
think that
that's
there was
her
an
not-
issue, did he? Did he think,
No,
it's
he-
not like he's saying, she needs therapy, and she needs to go, and I will attend with her.
Right, he
He's
said-
basically saying, she's fine, let her take care of the kid.
He said, I believe he said, quote, "It's no big deal. Schizophrenia is no big deal."
And
that's after.
isn't that an indication that the agency needs to do more than say, well, you just don't have insight?
But, well, they tried to, I think they did the best they could in terms of trying to get him to attend.
Well, it's not a
There-
question of whether or not they did the best they could. It's a question of whether or not they've met the statutory requirement.
Right, and I think they did by trying to get him to attend these services with her. It would have been the perfect setting.
I
It would
wasn't
have been
clear about, sorry, I
tailored-
wasn't clear about the record, because I thought the attorney for the child said essentially that the agency found out that the therapist had said that he could attend. Does the record say that the agency told him he should attend the mother sessions?
Yes, the record does say that, so the caseworker testified that she recommended that he sit in on her therapy sessions as allowed. That's in 253 to 254 of the appendix. And also, Pellin did testify that he believed he did sit in on some of her sessions, although he wasn't clear about
May I
that. So I
ask
think
something?
there was no, if he didn't.
I'm sorry,
Yes.
your light is on, and I just want to ask something somewhat differently. It seems a different avenue. It seems this petition's filed in April 2017, and there are hearings starting
I
in
think it was it August? I think it was August.
April.
Oh, it was April.
There are hearings, fact-finding over the course of roughly a year or whatever, and then there's a dispositional hearing that takes exactly a year. And then at the end of 2022, 5 years later, there's an oral determination entered. 2 years later, there's an appellate division affirms that decision. Is this standard, that it takes 5 years to get through these proceedings in court?
Usually not.
Just before you get to the appellate division?
Sometimes where there are interpreters, it takes a bit longer. Depending on if they are virtual interpreters, sometimes takes a little bit longer to get through cases. That's just my experience.
And so the first part's a fact-finding hearing, the second part's a dispositional hearing.
Yes.
If we were to reverse here, what happens when this goes back
Starts over.
with a fact-finding
Fact
hearing?
finding.
Do you have to file another petition?
Yes.
And it seems from the appellate division decision, and they were talking about the father's request to suspend the judgment, it wasn't warranted because the child was living in a loving foster home where his extensive special needs were being met and his foster mother wanted to adopt him. The child's now 11 years old, right?
Yes.
So if we send this back, it'll be 11 plus, and we will start the petition process that we just walked through again.
Yes.
Where is the child now?
The child's still in the same home, and my understanding is he wishes to be adopted. He's looking forward to being adopted. Yeah.
The father may very well not want his parental rights terminated. So
The father, I'm sorry,
the father may not want his parental rights terminated. That's the point of this appeal,
I'm sure he doesn't.
right? Yes, and it's a bit hard to wrap my mind around the failings of the system, if there are any. I understand you're saying everything was met and met the standard, but let's say the court disagreed with you, that the failings result in the termination of parental rights. That seems the height of injustice.
Thank you.
Thank you.
I'd just like to make 2 points regarding the time that the child has been in foster care. And the first is that the New York legislature enacted a preference for reunification of children with their parents whenever possible. And that's why it made diligent efforts, a threshold consideration, that has to be determined before any consideration of what is in the child's best interest. And I
So
also...
the child's best interest, as I understand that, you're accurate, is not a factor at all here.
It's not a factor at the fact-finding on the termination of parental rights. It's only a factor once permanent neglect has been proven. So if the agency hasn't met their burden, then the children's interests never are considered.
It's only considered at the dispositional.
That's correct.
And, but you would have to redo both, right?
Yes, and one thing I want to point out in terms of the timeline, it took about 2 years for the fact-finding to begin, I think in part because the mental health services evaluation of the mother took some time to be completed, and the delay between fact-finding and disposition was because of COVID. The fact-finding was completed before COVID started. So another point that I just wanted to make quickly was, in terms of the interpreters at visits, it's not just so that my client can communicate with the child, although of course that's important, and that is one of the primary purposes of visits, but also these are an opportunity for the case planning staff and my client to check in. That happens much more frequently than the case planning meetings, which are only twice a year. They would have allowed the case planner to help him prepare for the visit, to think of activities to do with the child, to give him feedback after the visit. They would have allowed
What
him.
about both counsel's statements that, as far as they could tell, the father never indicated that he wasn't able to communicate, that there was something else he wanted to say or wanted to be heard in a particular way, and he was denied the opportunity to have that kind of communication? Is that what the record reflects, or do you have some opinion or response?
Well, the father did testify that he sometimes didn't know what was going on at the visits, and he felt like a dummy because he couldn't communicate with anybody. So clearly it had an impact on him
But they say, but then there are these calls where there are interpreters, and of course at the conferences every 6 months there are, and they say he had his opportunity to communicate that to the caseworker at that point and the agency staff, and apparently he failed to do so. Again, unless you read the record differently, you can point to something else.
I think that the calls, I mean, I don't think there's evidence in the record about what exactly the calls consisted of, other than, probably scheduling visits and meetings and things. The case planner testified that the conferences were the time when she gave my client feedback about the visits. And I think
What responsibility with respect to reunification was that of your client here?
Well, Your Honor, because diligent efforts is a threshold issue, there's really no consideration of what my client did or didn't do unless the agency has first met its obligation. And that's in part because of the superior position of the agency. The agency has experience with these types of cases and knowledge.
Could your client obstruct their ability to address his needs?
No, Your Honor. My client was always cooperative with the agency. He did the services that they referred him to. He always stayed in touch with the
That's what I
case
was
planner.
asking you. What is his responsibility with respect to the reunification process, if any?
Well, in terms of the only way that my client's actions come into play in the consideration of whether the agency made diligent efforts is if my client was utterly uncooperative or indifferent, which he was not. He attended the services the agency asked him to attend.
Can I ask at the beginning, you said there were two aspects of the failure to tailor, and I think for the most part, you only addressed the first. What was the second?
Yeah, the first was his understanding of his wife's
Yes.
mental illness, and the second was the impact that his frequent work out of state had on his ability to visit and build a strong bond with the child, which the agency didn't help him solve that problem.
What
at
should
all.
they have done?
Well, they could have provided him with employment counseling or helped him find financial assistance or housing assistance so he could have afforded to support himself without needing to frequently work out of state. Or they could have just helped him problem solve. Like if it was possible for him to get other work than he was finding through these employment agencies, they could have explored that with him. But they didn't do anything to assist him with overcoming that obstacle. When they told him he should visit more frequently, and he said, but I need to work to support myself, and that was apparently the end of the conversation. They didn't further explore whether there was some solution that they could find to allow him to visit more frequently and build the bond that was necessary.
Thank you.
Thank you.